Hello, everyone. Welcome to Court with Krissy. Today, a defendant is here for a sentencing. His vehicle collided with another vehicle, and that driver lost her life. Never say never, dude. Like, ever. And before you get your boxers in a bunch because the video ends, I watched it before I recorded it. You're not missing much. Everything you need to see, you're gonna see. I hope you like it. Court with Krissy is now in session.
Thank you, Your Honor.
All right, Ms. Bailey Quick, have you had that opportunity at this point?
I have.
All right, is there anything you wish to say?
There is. I did provide last week some documentation to the prosecutor's office as well as to Your Honor, and I just want to make sure that you have that and have had an opportunity to look at that.
Yes.
Okay. I first would like to offer Mr. Harlan's deepest sympathies to Miss Anderson's family and son. Unfortunately, nothing, Your Honor, or this judicial system can do will change the circumstances of that day. And no punishment that the court renders will be as imposing as that of which Mr. Harlan has already received and lives with. He has the daily reminder of the loss of Miss Anderson's life and his own scars. And those scars are a constant reminder to him of what happened that day. I know that doesn't take away from, the loss of Miss Anderson's life and the pain that her family clearly, based on the victim impact statement, is dealing with. It sounds like there were a lot of external issues as well that further complicated not only, the circumstances involved in this traffic accident, that further exasperated the circumstances as well. I would like the court to consider the following, and I did provide last week the documentation. I know that there was the allegation that Mr. Harlan was using his phone. He acknowledged using his phone at the stop sign prior to leaving the stop sign and continuing on his path of travel before the accident. As I provided to the court, Mr. Harlan does suffer from type 2 diabetes, and at the time of the accident, his blood sugar had spiked and went almost 8 times the normal level of a typical individual. And just so that the court's aware, Mr. Harlan typically sees his primary care physician at OMH one time a year for annual appointments and monitoring for that diabetes, unless something else arises. But unfortunately, his PCP at OMH left the practice without his knowledge or any notice to him. He was receiving 3-month supplies of his medication for his diabetes before needing to call and ask for a refill. When he called and asked for the refill closest to the date of the accident, OMH said they were working on it. He called the pharmacy and the pharmacy said it hasn't been called in yet, and he'd contact OMH and they would just say they're working on it. It wasn't until after the accident that he was informed that his primary care physician had left the practice and that they were trying to find a doctor to submit the refill request. It's just, I tell the court that just to give some context. There was reference, at least in one of the ER medical record notes from Munson that he was medication non-compliant secondary to financial issues. And that just simply is not true. His medication was fully covered by his insurance, and he was compliant until they didn't refill it. And so the documentation that I provided did show that his glucose level at the time of the accident was 600 milligrams, which frankly is comatose level. His hemoglobin level was at a 17.5. Following that, his driver's license was appropriately revoked, and he now, being under the treatment of a new primary care physician, has his glucose level and his hemoglobin back down into normal ranges. And so it's important to at least show or note that when he's on his medication, that has a significant impact. I provided the medical documentation that showed that at the ER, it even noted that critical lab received, and that being that his glucose and hemoglobin was substantially over the normal ranges. And so, again, I just am asking the court to take that into consideration. I reviewed the recommendation with Mr. Harlan. He is working with the Secretary of State and does not have his license at this time. He is submitting the medical documentation as they've requested so that they can continue to monitor that. And so in reviewing the recommendation provided by the court with Mr. Harlan, believe it's a fair recommendation, and I would ask the court to follow that. And we can keep the court informed of any further changes with the Secretary of State as we continue to provide them with additional documentation.
All right. Thank you, Mr. Harlan. Is there anything you wanted to say?
Your Honor, I'm sorry. I have instructed Mr. Harlan not to say anything just because
Sure.
of the pending civil case.
I understand. Right. Okay. All right. That's fine. And is that correct, Mr. And I don't mean to bypass you, but I just need to ask him, based on what your attorney said, I understand you do not wish to say anything at this point. Is that correct?
That is correct, Your Honor.
Okay. All right. These are always incredibly difficult situations, as Bailey Quick observed, and as everybody knows. I mean, nothing that the court can do can bring your daughter back, ma'am. And my deepest condolences for this. I mean, if you're a parent, or even if you're not, it's an unimaginable thing to happen. And then I understand your husband's situation that gets multiplied in that. There's two losses, and so and those things are considerations. It's not a huge part of what I would do, but it's a very human part of these. I've had some both personal and professional experiences with cases like these, where you get an individual. I mean, it's not like your standard person who's just say a drunk driver and is out and crosses a center line and hits and kills somebody. And we read about those things. I fortunately have not had those, or if they have, they've gone up to circuit court, not been in front of me in district court. But I can think of at least two cases that Otsego County has had in the not too distant past, where there's been a situation where the driver was somebody completely without a record. And I know one of them pled guilty to, or no contest probably, to the very same charge that Mr. Harlan pled no contest to. And I think both of them did, that being, I believe, the charge of operating a motor vehicle, or a moving violation causing death, which is count 2 in this matter. And I understand and completely accept that the diabetes was part of it, A, based on the statement, and B, based on the medical records that were there. And I know the situation when the primary care physician wasn't there. On the other hand, and this was perhaps more so true than in the other two cases that I'm referencing, there was the choice to drive knowing that you had these conditions, and that's what the court is wrestling with, as to what to do. It is not the same level, at least in my mind, of culpability as somebody who spends the evening drinking and goes out and drives. But on the other hand, it wasn't, what in legal terms might be called a sudden emergency. So this is what the court is going to do on this. I suspect that probation isn't going to make a huge difference. Ms. Bailey Quick, is your client undergoing any type of counseling? The impact of this being responsible for another person's death has to have some impact on an individual. I'm not saying he needs to, I'm just curious.
He's looked into it, unfortunately, because he doesn't have a license, and due to all the other medical appointments he has, because he has significant ongoing medical appointments, his driver just frankly can't fit in another appointment. So it is something that he has indicated he needs to do. It's just something that he can't do at the moment.
All right, I do understand that. So I'm going to place you on probation for a period of 180 days. This would include a crime victim fee of $75, statewide judicial assessment of $50, court costs of $150, local charge of $15, $75 fine, and a probation oversight fee of $180. While on probation, and these are standard terms, there's to be no consumption or possession of alcohol or drugs unless those drugs are prescribed. You're subject to random testing. To the extent that you're able, and I'm not sure if the diabetes keeps you, or the car situation keeps you from this, but you're to maintain employment. The court will order 10 days jail to be served as follows: 5 days jail and 5 days work camp. And there's really no satisfactory sentence that I can think one way or the other. Deep and grievous loss. I'm also going to order the decision-based driving course that's referenced in Ms. Hill's report to be completed. And she'll be able to give you the details of that. But there's no sentence that's really satisfactory one way or the other. In some ways, it might be viewed as harsh, and in other ways, it might be viewed as lenient, and I get both arguments. And so I leave it on that. And with everybody here, and I know, Ms. Shields, once again, I condone, really, truly, deepest condolences on this. Ms. Bailey, quick, when would your client like to begin his sentence?
Never.
Could we possibly do like a Thursday so that he can not?
I have no problem. I have no problem starting on Thursday. So does he work Thursday or not?
He's unable to work currently. Okay. It's his medical appointments, Your Honor.
That's fine. So start Thursday, October 11th. I'm sorry, October 31st. At 9 a.m.
Your Honor, I'm sorry. He just told me that he has an appointment this Friday with his primary care that's been scheduled since May.
I have no problems with starting Saturday the 2nd then. So that'd be November 2nd. Mr. Harlan, they'll be expecting you there. Before then, I'd like you to call probation so you can get oriented to probation. They can explain more of the details to you. And that number is 989-731-0000.